I didn't ask you, John. But I'm concerned. Are you prepared? You got your walker or a chair there? What do you got? You got a chair? Good morning, ladies and gentlemen. I would like to welcome you. Boy, time flies around here. Tuesday, May 1st, 2012. I'd like to call this meeting to order. I'll begin by introducing my colleagues and myself. I am Board Chair Charlie Hoppen. To my left, Vice Chair Francis Pivey Weber, and to my right, Board Member Tam Doduk. And no, we don't have any other board members. There are the three of us here. Mr. Howard, would you please introduce your staff?
To my right is Karen Turgovich and John Bishop, Chief Deputies. To my left, Michael Laufer, Chief Counsel. We're assisted today. The board is assisted by Janine Townsend.
Thank you, Tom. I see a lot of familiar faces. I'm going to have to go through the emergency evacuation procedure. Regardless, if you do hear an alarm or a bell go off, if you would proceed down the stairs, and I've been instructed to be very serious in telling you that you need to go to J. Neely Johnson Park and Community Garden located at 516 11th Street between E and F. And please obey all traffic signals. And don't forget to pin the note from your mom on your shirt so they know where to return you after the fire alarm all clear sign has gone off.
So much for seriousness.
Yes. Our meeting is being webcast and recorded on a very serious note, so when you come to the podium, please identify yourself and whom it is you're representing. If it's not yourself, but please speak clearly into the microphone. And importantly, if you would turn off or silence all of those electronic devices that we all depend on so much. We do not have any cards for a public forum, but there is an opportunity for members of the public to speak to the board regarding matters that are not immediately pending before us. Is there anyone here that would wish to do so? Seeing none. The board will consider minutes from the April 17th, 2012 board meeting.
I move adoption.
And I will second. All those in favor?
Aye.
Thank you. Ladies, do you have anything you would like to report to everyone?
Go ahead.
I have one item today at 4 o'clock at UC Davis in the Mondavi Center Theater Room is going to be the first lecture for the Ann J. Snyder Foundation. And Judge Roby is going to be giving the lecture. And so for those who can get there at 4 o'clock, I think the board meeting will be over by then, will it not, Mr. Chair? But it's a great tribute to Ann, and this is the first, so there will be many in the future. And if you've got some recommendations of people who are thinking about law and policy and public space, give those ideas to Art Baggett at the back or to a number of us, and we will make sure they get in the hopper for the future. Thank you.
And I have two actually quite positive reports from two regional water boards. First of all, I attended the North Coast Regional Water Board meeting in Santa Rosa last week, and they had a report from the Dairy Quality Assurance Program as well as various stakeholders in the area on their dairy program. And it was, in short description, a love fest. When the regional board started that effort several years ago, there was quite a bit of angst, as you can imagine, from all involved. But the staff, in the direction of the regional board leadership there, worked with UC Davis and the entire Dairy Quality Assurance Program. And from the report that I heard last Thursday, it's been a tremendously successful partnership. In fact, Deanne Meyer from UC Davis, who spoke on behalf of the partnership, called it almost a joy to work with, and one of the most successful efforts she's been involved in. So kudos to the regional board, to the staff, and to the industry and the Dairy Quality Assurance Partnership for working together and creating something that seems to be working very well. And then a report also from the Santa Ana Regional Water Board meeting last Friday. If you'll recall, the regional board has been working on updating their basin plan on the rec standards for their basin plan was an issue that they did come, their executive direct officer came and presented to us because there was some level of controversy, and our own staff as well as US EPA staff had voiced some concern about the stakeholder-driven process. Again, another regional board who's very much into the collaborative stakeholder process and the effort that they've been putting into updating the rec standards, the beneficial use designation as well. And I'm pleased to report that even though Santa Ana Regional Board did not have a quorum on Friday to act on this item, they were able to work with staff and with EPA to amend their proposal in such a way that I believe that EPA and our own staff no longer has at least the tremendous opposition that they had before. So once again, nice collaboration by staff, stakeholder, and agencies.
Tam reminds me that we use the same phrases over and over at times, and I'm sure to some of you they get kind of boring or say, oh, they go with bureaucratic doublespeak. But the terms stakeholder and collaborative process and transparency are very indicative of what Mr. Howard is going to introduce to you in a moment. You know, we're often accused by members of the public that do things that we don't like, which there's a lot of, that we haven't been involved, we don't know enough about this. The item that's going to be introduced, I think, is living proof that people come together and try and resolve things in a way that, in my belief, is very efficient and allows us to use limited resources for other more urgent means without turning our back on other needs, if you will. So I appreciate Tam's comments. You're about to hear an item that I think typifies our commitment to stakeholder processes and collaborative work. Mr. Howard, would you introduce item number 3, please?
Kevin Graves and Lori Brock will be the two staff people presenting this item. It involves the approval of the adoption of a water quality control policy for low-threat underground storage tank case closures, and also the approval of the substitute environmental document associated with that policy. Kevin?
Good morning, Mr. Chairman, members of the board. I'm Kevin Graves from the Division of Water Quality, and with me today is Lori Brock from the Office of Chief Counsel. This item presents for your consideration the low-threat UST case closure policy and the associated SED. This policy was developed by a stakeholder group, as you mentioned. For the past 9 months, has been undergoing CEQA reviews, scientific peer review, and public comment. A redline version of the policy was noticed on April 20th and included all staff changes in the response to peer review and public comments. We noticed a clerical error in the policy that I'd like to point out for correction. On page 9, under the heading Low Threat Closure, there's a list that reads AAB, and it should list ABC. While staff have made a number of changes to the policy since it was first presented to the board last July, we've tried very hard to adhere to the spirit and the details of the policy as it was written by the stakeholder group. I'd like to briefly cover 3 areas of comments and then turn it over to Lori. In Table 1, which is the direct contact concentrations for cleanup, you'll notice that there's a dramatic change in the cleanup levels in that policy, that table. And that's a direct result of one of the commenters, Howard Whitney from Remediation Testing and Design, took it upon himself to go through the laborious calculations and recreated an Excel spreadsheet of all of the toxicology stuff and found that there was an extra term for body weight that was in one of the calculations for inhalation to outdoor air. And so after conferring with our experts, we had to, agree with Howard that he was right, and we needed to change the numbers in the table. And so that's, we appreciate his attention to detail on that, and we think the policy is better because of that. TBA.
Can we add him to the list of potential future peer reviewers? Apparently, he got something our peer reviewers did not.
Howard's here today. Maybe he'd like to sign up for that, yeah. TBA is tertiary butyl alcohol. TBA is a breakdown product of MTBE, and it has been showing up in plumes around the state at increasing quantities as MTBE breaks down in the environment. And it's something that we have noted, but we didn't specifically address it in the policy. It's addressed in the policy because all of the constituents in the plume need to be investigated, and that we need to determine how big the plume is. And so by saying all constituents, it includes TBA. We just didn't break out all of the ones that you would look at on an analytical report. And we didn't include it from the we have MTBE and benzene numbers specifically in the groundwater criteria, and we didn't include TBA because those MTBE and benzene numbers are intended to limit the amount of source mass that can be left. And since TBA isn't really associated with free product removal and vadose zone remediation, it's really more of a groundwater plume issue. We didn't think it was appropriate to really include that MTBE and benzene were the classic constituents to use for that. And so that's why we left it at that and didn't include TBA. And lastly, there's some commenters wanted greater definition of what was what could be exempted from the policy under the case unique site-specific conditions. Fractured bedrock was brought up, sensitive areas of basins was brought up, and we decided that we could go down the road of trying to specifically illustrate all of those different things, but that the one catch-all was really a better way to go, in our opinion, from the staff level. That trying to list all of the different types of site-specific conditions that were unique took away from the concept that they were unique site-specific conditions that we couldn't identify. And so we did not include that comment. And with that, I'd like to turn it over to Lori.
As Kevin mentioned, revised versions of the draft SED and policy were distributed on April 20th, and they reflected staff changes and strikeout and underline. There were some minor changes to the substitute environmental document. Mainly, we broke out the number of cases by region that were open UST cases, and we highlighted the fact that case-specific information is in great detail on the State Board's database GeoTracker. The notice for this agenda indicated that written responses were limited to the revisions to the SED and the policy as they were distributed on April 20th. We received 4 timely comment letters, three of which were non-responsive to the changes. They went beyond the scope of the changes and provided additional legal argument. One of the comments that we received was within the scope of the changes of the documents, and that's the comment that Kevin mentioned about expanding, providing an example of a case that meets a unique site condition. The staff report was posted on Friday, as well as response to comments and response to peer review. During the written and the public comment period, the oral comment period, there were several comments about the substitute environmental document, and in particular, the baseline that was chosen to prepare the supplement, the SED. Normally, existing physical conditions are used as the baseline for determining whether there are impacts and whether impacts are significant. A number of commenters have said or argued that the baseline that we chose was inappropriate, and that instead we should have used the existing regulatory framework, meaning what the closure criteria are now under the existing case closure framework. The case law doesn't support that. The CEQA guidelines and cases that interpret CEQA provide that normally the baseline is the existing physical conditions at a site. Cases have held that it's inappropriate to use what is called the regulatory framework, which is what could be done under the existing policy. Commenters have recently brought to our attention a case that was just decided on April 17th, and that is a case that they believe justifies using a different baseline for purposes of this policy. In that case, the court did allow a different baseline. They looked at a projected future baseline rather than the existing conditions at the time that the environmental review began. And the reason was it was a long-term rail infrastructure project, and they believe that projected future conditions that were based on substantial evidence were a better means by which to evaluate impacts from the project that would not be implemented until, say, 20 years out. So in our view, that case does not provide a basis for changing the baseline in the supplemental environmental document for the proposed low-risk policy. So from there, when we evaluated the baseline based upon what we believe that CEQA guidelines and the case law require, or that is consistent with applicable case law, we looked at impacts that would be caused by the project. We identified impacts related to the destruction of monitoring wells and the removal of debris that's related to closure, and we determined that there were impacts, but they were less than significant.
Thank you, Lori. Do either of you have questions? We have some public comments. Riley Hurd, would you come forward, please?
Morning, members of the board and staff. My name is Riley Hurd. I continue to represent Mr. Larry Turner in connection with this policy. Actually glad I got to go first and follow up on Ms. Brock's analysis. She was referring to a letter and a case that I provided to the board. And I just want to point out that today really is the board's chance to decide whether it wants to follow what is clearly the developing law when it comes to CEQA, or not when it comes to this admittedly much needed policy. I think it's pretty interesting that throughout this process, no one has stood up here and said, we don't need this policy, not one person. So the concept is widely accepted, but I think the environmental review and the process are the only two things I'm going to mention today. The failure to use a baseline that meaningfully analyzes the difference between your current policy and the proposed policy results in not only you, but the public as well, not knowing the true environmental effects of any decision you may make. So I did send a letter about this new case, and it did two important things. First, it said, there are situations where looking at what might happen in the future is the right thing to do. If it makes sense, if that's what you need to do to get a realistic look, then do it. That's what this new case said. And it completely undermined the case that still remains in your SED, the community's case. It said, no, you don't always, every time, only look at existing conditions, just what's in the ground. You can extrapolate. You can look at what was going to occur. And secondly, and this is, I think, even more important, the court continued to use the same reasoning for reaching that decision, and that is giving you a realistic look at what the existing conditions are. And I would submit that if you have a long-standing policy in place about cleaning up UST sites, to then just ignore that policy, pretend it doesn't exist at all, and say there's just pollution in the ground, and what we do now will address that pollution, is not realistic. And by not using a realistic baseline, you undermine the entire purpose of CEQA. So before I conclude, I know I'm short on time, I want to address one other thing, and that's the Administrative Procedure Act. I believe that the process by which this policy has been prepared violates the APA and therefore should be rejected by the Office of the Administrative Law. So it's not just CEQA that requires you to look at alternatives. So under the SED, it was determined we don't need to look at alternatives. The APA says you must meaningfully analyze alternatives to a policy, and that hasn't been done here. It also requires a consistency analysis with other laws and your own laws. I've pointed out where some of the things in this policy are inconsistent both internally and externally. Finally, the last-minute data dump on Friday, 40 pages of 8-point font comments, all types of new updated technical justifications. It made it very difficult for the public to participate in a meaningful way, which is what the APA is designed to do. So I want to conclude by saying that this policy is needed. Everyone agrees with that. But the baseline is actionable under CEQA. It's not the existing conditions, which is the robust UST regulatory program you already have, and it's not reasonable future conditions, which would involve remediation of more than what will be remediated under the policy. So I'd ask when you vote today, consider whether you can truly state that this policy has no effect, none, on our state's water quality. That is what a yes vote means, that you believe that fact. If you do recognize that this will have at least some effect, any effect, on the state's water quality, then this item should be continued and a proper analysis performed. Thank you.
Thank you, Mr. Hurd. Howard Whitney?
Thank you, Mr. Chairman and board members. My name is Howard Whitney with Remediation Testing and Design. I support the policy and I recommend that you adopt it as written. This policy is based on science. It's focused on source removal. And I think one of the most important aspects of this is it recognizes soil and soil vapor as primary risk targets. The older policies that were employed in an ad hoc manner, not entirely based on science, focused unnecessarily on difficult groundwater cleanup that did not improve public health, did not improve groundwater quality, and wasted a lot of money. The new policy will streamline and focus remediation on the source removal, which is the most important aspect of UST cleanup. And therefore, the new policy will actually improve cleanup and lower long-term risks. The process has been fair and transparent. I don't agree with every little detail in the policy, but it's a very good policy that qualified scientists and engineers can work with. So please adopt the policy as written, and let's move forward with getting these sites cleaned up and closed. Thank you.
Thank you, Mr. Whitney. Craig Johns?
Thank you, Mr. Chairman and members of the board. My name is Craig Johns. I'm here today as a project manager for the Partnership for Sound Science and Environmental Policy. PSEP also supports this policy by the board and urges adoption today. We did submit a letter, but perhaps it was part of the group that was deemed outside the realm of the comments to be accepted. I'm not sure, since those weren't identified specifically. And I'm not going to go through the points in our letter other than to say a couple of things. First of all, as was pointed out by Mr. Whitney, I mean, this policy is based on good science. Obviously, the peer reviewers that were assembled by the University of California, some of the most eminent folks in this area, in these areas that were studied by the state board and by the peer reviewers, although they had comments and suggestions for improvements, the common refrain that you heard or read in most of the peer review comments were that this represents a conservative and sensible approach to dealing with this problem of low-threat UST sites, and I think that the peer review comments in that vein speak volumes. We would like to recognize, although we recognize also that there were many, many staff from the board, state board here, as well as from the regions and local oversight agencies as well that helped to bring this policy forward. We would like to recognize Kevin Graves for his work and leadership on this policy, and James Giannopoulos before him. I was hoping he'd be here to see what seems to be, or hopefully will be, the culmination of many years of his efforts. And last but not least, the efforts of Board Member Dodak in spearheading this a couple of years ago and taking it on. It's been a huge, an enormous effort on her part in trying to herd the cats, as they say. My last comment is to say that, yes, we do support it, but we also recognize that the next step that we urge the board to take is to come up with, or to ask staff to come up with a workable, implementable policy for appeals processes for those individuals who think that their sites do qualify for closure under this policy, but they might be in locations around the state where you have either local oversight agency staff or even regional board staff who are perhaps hostile to the underlying premise of this policy, can have their day and get these sites reviewed, not in the customary way that I think we've been seeing them over the last couple of years, where they're brought to the state board in a somewhat inefficient manner. With that, I want to thank you very much for all the work on this.
Thank you, Craig. Kevin or Lori, Craig raises an interesting point. I mean, as Mr. Whitney said, as Mr. Hurd before him said, this isn't perfect. Nothing we do is absolutely perfect. And, you know, there are circumstances, as much as we try to make this all encompassing, there are circumstances that will be anomalies. How would you envision this appeals process, and how would we do that in a functional way? Because I think, you know, it would be an integral part of the successful program here.
Well, we always hope that appeals and disputes will be handled at the lowest level possible, and so that
With us?
before we get to you, that the local agencies would be working with responsible parties and the regional boards would be working, and that disputes, for the most part, would be worked out by taking another sample, putting another well, whatever it takes in order to get the data necessary. We currently have a petition process in place that admittedly has some administrative bottlenecks in it that we can work on removing and minimizing. But for the most part, the petition process that we have now, where people can dispute their any action or inaction of a local agency or regional board, will ultimately be the result of disputes. That process will remain in place, and if we cannot resolve them beforehand, that you would be still seeing petitions of action.
And Lori, from a legal standpoint, if what we're doing, if we get into this, if we see some flaws in it, that's adaptable. Is that correct? I mean, it's not part of something that's...
As we see real-life cases, the board can consider and adopt precedential decisions that further refine what the policy is intended for, or the policy can be revised if we find, you know, recurring issues that we think require a general or standard modification to the policy.
Well, hopefully we'll never have to do that. I just want to be very clear that the option is there in the event that we do see a need. So thank you with that. Olivia Jacobs. You know, Olivia, last time you were before us, I didn't admonish you, but I had to admit I couldn't read your name, and this could not be clearer today. So normally people don't pay any attention to me at all, and I appreciate you doing it. So
I wasn't quick enough last time. I was informed in the past decade of working in the asbestos industry that the third most common name in Mexico is Olivia. So
well, this is perfect penmanship, young lady. So
I tried. Thank you for having the hearing. Thank you, board members and chairman. I gave you all something to look at. I didn't share it with everybody or on PowerPoint because it's a client's home and I didn't want to make that into a public image. So, and actually I submitted two responses by Thursday noon, and I guess they didn't seem responsive to the policy or the red line or the SED. I don't beg to differ, but here I have two things to say. So if you bear with me. Since I provided comments on the low-threat UST case closure policy 2 weeks ago, your office has produced a red line version of both the SED and the policy. Significant changes were made in the red lines of the policy. With all due respect, these red lines pale in comparison with the 117 pages of supporting documents which were posted on the website, the SWRCB website, on Friday night 4 days ago. 3 extensively updated technical justifications, a staff report, and 40 pages of comments make up this new 117 pages. We are superhuman, but this is too much. We cannot review this much material within this amount of days. Before I start with my prepared comments, I would like to recognize the level of work which went into these documents posted on Friday night. There's some very nice stuff in here. It's commendable. They really worked hard and they came up with some good stuff. But I have hardly had time to really make sure that everything is, how can we comment to that much stuff? So I'm here today expressly to request that the board defer its action of SED and policy approval to a subsequent meeting. I would propose a minimum of 60 days for public comment to these 7 significant documents. Because basically, yes, there are updates of what was there before, but there's a lot of new material here. So the second thing I wanted to say does relate to low threat closure, because basically if you're leaving stuff in the ground that you haven't dug up, then I feel that there's a duty of hazard communication which is not being recognized. I think that it's something that could easily be added to the policy, and I think that it's something that could be easily added to GeoTracker to amend the status quo. Let's see. So the item number 7 on the agenda was, on one of the iterations here, was the State Water Board has adopted numerous orders closing UST cases after applying relevant statutes and regulations referenced above and State Water Board Resolution 9249. In these orders, several factors were considered, such as 1, whether remaining petroleum constituents would migrate beyond a limited spatial extent. So the low threat policy would close sites with residual petroleum in place. My proposal, their extent should be mapped in a clear and public way. I cannot say enough good things about the GeoTracker site, which your board supports. However, despite the power of the database, there's evidence that adequate communication of the current spatial extent of contamination is not provided by GeoTracker. I highly recommend that your office upgrade the existing GeoTracker programming so that data points visually reflect the aerial extent of contamination. Since the SWRCB's GeoTracker site is a current database and the staff is already staffed to plot the data points in a low threat policy future in which residual masses would be the norm, the Water Board should upgrade their plotting to better reflect residual contamination plumes and residual soil contamination on GeoTracker. SWRCB has been tasked with reducing the cost of UST site cleanups with the USDCF. All agree that changes will need to be made by the Water Board in regard to the funding procedures. The database GeoTracker is already maintained and reflects UST release sites. On this webpage, the public has access to all the uploaded environmental contaminant release site reports, boring logs, analytical data, and regulatory letters. Currently, only the wells are mapped on the GeoTracker site plan view, and that's what I provided. I provided a 2-page. The first page is basically when you open up to the site, this is what you would see. You would see little dots. If you get close enough up on the map, you see little dots that represent the wells. And each well is, I did it in black and white, but it's pink. It's on the screen version, it's pink. So let's see. This plan view does not afford any value in regards to signifying the location of the residual mass or plume. A modification of the geotracker mapping of wells should include a shading of the well points to reflect the degree to which each data point contains contaminants of concern. At this time, the geotracker wells are shown as pink shaded circles. A very simple change to this depiction would clearly show several important facts. First, whether the lateral horizontal extent of the contamination has been determined. Second, how much contamination the migrating groundwater contains. And third, under whose property the plume of contamination has or could be expected to have migrated to. With an understanding that the draft low threat policy clearly allows residual contaminant plume presence, there's a low cost and obvious solution which has also many benefits. First, footprint of these residual plumes, which are not currently clearly mapped, will be visible. Second, the entire matter of public hazard communication is simplified for utilities sending workers into trenches. Subsurface workers frequently encounter contaminant fumes and free product. The USA Underground Service Alert feature could include a geotracker check to document and advise of areas in which residual plumes left in place are going to be encountered. Deed-restricted areas could also be plotted for the same hazard communication function. The Water Board proposes a low-threat closure which presumes a residual allowed. All of these maps would definitely need to be upgraded assuming the policy is implemented. Why? Because large volumes of petroleum hydrocarbons are going to be left in place. The Water Board provides an excellent internet resource which already identifies each release site on a map. The current limitation is that only the presence of contamination is shown and designated with a box which is located on the site. The degree and extent of the contamination are not shown on the map interface. Within the past couple of years, the exact locations of individual sampling well locations have also been plotted and are visible on GeoTracker, and that's what I showed you with this, so you can see where the wells are, and this doesn't have the box because you have to get closer up from the box view to get to the well view. In the first layer of the map, the first map, which is visible to the public with no specialized knowledge required, now each of the wells associated with the release is visible. With the current GeoTracker mapping, however, if the public wishes to see the extent of contamination, kind of contamination, degree of contamination, finding the appropriate document within the page is an arduous task which requires some degree of sophistication. Additionally, sometimes for various reasons, reports on sites, especially old sites at which residual has already been left in place, are not available on the GeoTracker website. There is sometimes another place to look for these reports, as some non-Water Board agencies, some of the LOPs, maintain their own websites, and more information is located there. In the current situation, the extent, kind, and degree of the contaminant plume is mapped by consultants. These maps are embedded in reports. On these maps, the degree of contamination, contours of specific contaminants are mapped. In most reports, a contamination contour which matches the closure levels are shown, as well as levels of contaminants which are higher. The objective of the mapping is to show where the contaminant is highest, lowest, and where it does not exist at all. The objective is to show background, not contaminated, area in the up-gradient direction as well as cross-gradient directions. And the lack of contamination in the down-gradient direction is also needed, so that the full extent of the contamination can be identified. In addition, at this time, the most contaminated level in each well can only be found by looking into the reports. This is a very tedious activity. There is no way to quickly visualize the extent of contamination in plan view on the first GeoTracker map. The current wells on GeoTracker could easily be color-coded. For example, coding the wells by color would represent extent of contamination. Color coding would be an easy way to migrate data to the front map so that the data are not just embedded in the report, but are clearly on the GeoTracker general maps. And what I did on your example is I went ahead and gave you color coding. So
Ms.
you,
Jacobs, if I could interrupt, even though the staff didn't mention it, we have your letter.
Okay.
We have your letter, and so your reading it into the record is not necessary.
okay. Well, I did have
Okay.
some extra visual. So I can wrap it up. The only other thing I wanted to impress upon you is that, hazards are encountered as people are trenching, and, fumes and free product are encountered, and you really need a visible way for people in a USA, underground service alert capacity to be able to see what they're going to get into. And it would be very easy to wrap your arms around the fact that you're leaving stuff in ground, and you need to be able to show people where it is. So sorry to be so long-winded. Thank
Actually,
you.
like I said, your letter is in the record. I did read it, and actually, I was going to follow up with staff with respect to your recommendations on upgrading GeoTracker. And I'll wait for staff's sidebar conversation to finish. What is the process we have for looking at GeoTracker and performing upgrades along the way? Is it a periodic, continuous process? In other words, I believe Ms. Jacobs raised some good points. Is it something that could be considered as part of the GeoTracker maintenance upgrade process that we have?
Yes, we do periodic updates of GeoTracker. There's a process that we go through for IT contracting. All state agencies go through those, called developing a feasibility study report, FSR. We can do those internally now, and we're actually in the process of developing that next generation of FSR.
Okay.
And some of the things that she mentioned are actually in that FSR. The ability to upload shape files that show where a plume is. Regulators have identified that as something they'd like to have, and it's actually one of the capabilities that we would like to add. Another, the color coding of wells, is something that the Gamma program already does. We call them heat maps, and it allows you to zoom out to a much larger view and see a wider perspective where plumes are based on the color representation of the concentrations in wells. And so, but she's very right that information technology these days is we're able to present things so that you can quickly understand them, and we look forward to bringing many of the things that she talked about into the GeoTracker in a short order.
So while the specific upgrades and changes to GeoTracker is not going to be specifically addressed in the low-threat policy, I concur with your recommendations, and I would urge staff to talk with you and see, how it is appropriate to incorporate into the GeoTracker upgrading process. And we do really much appreciate your thoughts on that area. I also wanted to address your other comment, which I think others have raised today, regarding the recent uploads of documents and responses to comments and the updated technical justification documents. We're all faced, like you, with the tremendous reading assignments over the past few nights, which is why I was so late this morning. But it is something that for those who, and I may look to our attorneys to weigh in on this, but unless the changes that staff has proposed is significant, we don't often offer another additional comment period, because otherwise you get into this continuous loop of responding to responses.
I appreciate, my only comment was that the original justification papers were, in my opinion, not even C grade. We're getting up to like B+ or A- grade with the ones that are here.
Well, I'm glad to hear that.
Right, but I don't think that's fair to the public, the scientific community, that we should have, been given this kind of C grade stuff, and then now when you give us the good stuff, we don't have time to really comment on it. And I haven't even figured out what the delta is on what the first and the second were. So
I appreciate that, but I especially appreciate the B+, A- comment. We always strive to improve, and that is part of the public process, to release a draft, even though it may be a C grade level, to receive comments, and therefore, by using those comments to improve our products. And in this instance, what staff did, the revisions, the changes, the new documents that were posted, granted, they were posted with very little time to review, but in my opinion, they were responses to the comments and the inputs that we provided, and in my mind, were not significant to such an extent that it would require additional 30 or 60-day period, which we often do when they are significant, like our stormwater permits, for example. So we do take into account the need for additional public comment when it is merited, and in this instance, I don't believe it is, but I do appreciate your comments.
okay.
Olivia, it may not be any consolation, and this isn't a reference to either Kevin or Lori, but similar things have happened to this board at different times in history, and we've been as rankled by it as you were, so just know that you're not alone.
Okay,
Fran.
the only other thing was that this, 117 pages was not actually put out by Lyris. Basically, I was searching around to see if anything had happened, and lo and behold, there was a ton of documents there. So it wasn't publicly noticed, FYI.
Lori?
It was posted on the state board's website, which is required by the regulations. We're not required to provide a notice. Most documents have been sent out through Lyris, but this was adequately posted on the state board's website.
Fran, you have a comment?
What is the timeline for the contract with, for GeoTracker, for completing the new contract with on GeoTracker?
We're currently reviewing the FSR, which is the description of the next round of changes. I don't have a firm date for you. It's probably going to be reviewed at the next MCC. So we're in the months time frame, I would think.
That's what I was trying to figure out. Thank you so much.
Thank you. Belkey Rank?
Hi, good
Good
morning.
morning.
I've got some prepared remarks here this morning for you. Good morning, Chair and members of the board. My name is Elka Rank. I'm with Zone 7 Water Agency out of Livermore in Alameda County. Zone 7 appreciates this opportunity to comment on the newly revised draft policy for low-threat UST case closure. Zone 7 is a wholesale water agency that serves drinking water to the cities of Dublin, Pleasanton, and Livermore, as well as irrigation water to a vibrant agricultural community. Zone 7 is also the local groundwater management agency for the Livermore-Abernor Valley groundwater basin, and we've aggressively managed that basin for over 50 years using a combination of artificial recharge and controlled groundwater pumping. Excuse me. The local groundwater basin is and always will be the backbone of Zone 7's water supply and storage system. It is the key to providing a sustainable and reliable water supply for over 220,000 people and 3,500 acres of agriculture, seeing the area through years of drought and plenty. Zone 7 is continually working with other regulatory agencies to protect and manage the local groundwater basin and associated watershed in an environmental friendly manner. In the future, Zone 7 plans to develop new well fields and add new recharge facilities to improve integrated water supply operations, including artificial recharge, groundwater storage, and improved groundwater quality, enhancing water supply reliability. As previously stated, Zone 7 supports 99% of the proposed policy. The concept of closing low-risk leaking underground fuel tank sites makes good environmental and economic sense. The draft policy attempted to protect existing supply wells, but it inadequately protected beneficial uses of managed groundwater basins because the policy did not account for future plume instability, which could result from changing conditions such as enhanced conjunctive use operations. A stable plume today might remobilize if additional recharge or pumping activities are initiated, or if long-term storage during drought or plenty cause more significant variations in water levels. Similarly, the environmental documents inadequately consider the cumulative impacts of closing low-threat UST sites. Although proposed staff revisions attempt to address these issues, Zone 7 feels that the draft policy needs additional changes to recognize the unique nature of water quality threats to managed basins. Additionally, it remains unclear how groundwater management agencies' comments and concerns will be addressed when applications for such site closures are received. Consequently, Zone 7 requests that the board consider additional changes to the policy so that it clearly does not apply to UST cases overlying managed groundwater basins. Zone 7 would wholeheartedly support this policy with such an amendment. Thank you.
Kevin, I know I've asked you the question, but in response to Ms. Rank's question on USTs that are cited overlying managed groundwater basins, would you please respond to her comment on that?
We think that the policy, has protections in place that not only do water districts and others, the public have a comment period at the end when all of the work has been done on the site, but there's also opportunities to get in at the beginning of the process. And we would really encourage water districts that manage their basins to understand where the leaking underground tanks are and participate in the regulatory decisions throughout the life of the case, and not rely on at the very end of the process to try to jump in and change things. And so we think that the UST program in general allows for that, and that we encourage them to take advantage of those opportunities.
Thank you for that. That concludes our speaker cards. Ladies, do you have any comments, questions of staff?
I actually have a motion.
That'll do.
Before I make my motion, though, I do want to take a moment and thank staff, Kevin, Vicki, Lori, and others who've worked so hard on this effort. Thank the stakeholders group who volunteered their time and expertise and sat through numerous tense discussions of the
In reality, they didn't have any choice considering the taskmaster they had in front of them, Ms. Doduck.
Well, I plead guilty on that one. This policy is something that I think is long overdue, and it was important that we took the time, working with staff, with stakeholder, to build a scientific basis for it. The stakeholders who were a member of that work group who are in the room will remember that I, many times,